Hi, so this is the first video lecture on Factories Act. It'll be a series of lecture covering different topics under the Act. The only request that I have for to you is that please pay attention to the lecture in the background along with the PPTs because I won't be reading out the slides per se. So the slides on the in the video are for your reference, which will anyways be available. But please pay attention to the lecture in the background, which covers slightly more explanation and details about the topics that are going to be covered. So we'll be starting with the Factories Act. As the year of enactment suggests, it is one of the oldest labor welfare legislations in India and also one of the most important ones. It is a piece of social welfare legislation which is created primarily with the object of protecting workmen employed in factories against industrial and occupational hazards. So, the background of the act is that when the modern factory system started with the growth of industries and factories, the worker class became more vulnerable to industrial accidents and occupational hazards. So, occupational hazards does not necessarily mean or is not restricted to accidents only or to occupational diseases per se, but it covers a wide range of things which fall under your working conditions. For example, long and excessive hours of work, to poor housing facilities, to excessively high death rate. So, because there was no formal legislation which governed the working conditions of workmen, they were prone to more exploitation, they were prone to more accidents, and there was no safety that was provided for them. So, the first Factories Act was enacted in the year 1881. However, the focus of the act was very minimal. It was only to protect children and provide some basic health and safety measures. Hence, with subsequent amendments, there were a lot of gradual changes that were brought in till it was all repealed and a new act was brought in the year 1948. This act was an attempt by the government to be in consonance with the ILO Code of Industrial Hygiene, and the primary object of the act was to protect human beings from being subject to unduly long hours of bodily strain or manual labor. Now, with the Factories Act of 1948, some very important changes were introduced as compared to the earlier legislations. First is that the definition of the term factory was widened in its scope. So it now covers all industrial establishments with 10 or more workers where power is used and 20 or more workers in all other cases. Second, there is no distinction between seasonal and non-seasonal factories now. Third, earlier legislations had a very few provisions with respect to health, safety, and welfare of workers, and they were all clubbed together in one chapter with very minimal provisions. With this new Act of 1948, which we still follow till date in India, there are separate chapters dealing with health, safety, and welfare measures, respectively, of the workers, and for each for each of these chapters, for each of these measures, separate minimum requirements are also provided. Fourth, the Act extends its health, safety, and welfare measures to all workplaces, irrespective of the number of workers, except where the process is carried on by the occupier with the sole aid of his family. The next important change is that the Act of 1948 raised the minimum age for admission of children to work in factories from 12 to 14 years. Now, the age of 14 years as provided in the Factories Act is also not in consonance with the Constitution of India, it is not in consonance with the Child Labour Prohibition Act because they provide for complete prohibition of children below the age of 18 years. However, this provision has still not been amended in the factory legislation. And along with raising the minimum age for admission, the minimum permissible daily hours of working for children was also reduced from 5 hours to 4.5 hours. Next is that now the legislation provides for compulsory licensing and registration of factories, and a prior scrutiny by the inspector of plants and specification of factory building is also provided. And the last important change is that it grants power to the state government to make rules requiring association of workers in the management for welfare of the workers. So in essence, what the Factories Act strives for is to provide a safety net for the workers. At the same time, it has to be ensured that although the law is created for the benefit of employees, it should not be used merely for the purpose of harassing the employer. So that balance has to be achieved. Through different judgments, the courts have also time and again reiterated that the Factories Act is a social enactment which intends to achieve a social reform. So it must always be given liberal construction. So the benefit always goes to the workman. However, the interest of the employer still has to be balanced. The entire idea behind enacting this factories legislation was to provide an incentive or to sort of generate an interest in the worker to devote their time and labor in the working process of the factory without being afraid of bodily strain and without the fear and danger of infection and accidents. So, unless you have that kind of an assurance or a safety net or welfare provisions in your place of work, you are constantly in the fear of meeting with an accident and thereafter not being taken care of. So, this act provides those minimum standards, provides those minimum welfare measures, safety measures, which have to be mandatorily adopted in all factories. In the context of the need to secure maximum production and productivity, an appropriate, conducive environment to the health, safety, and happiness of workers needs to be evolved in the factories, which is what this legislation targets. The object of the Act is threefold. First, that it is a labor welfare enactment codified primarily to regulate working conditions in factories and to provide health, safety, and welfare measures. Health, safety, and welfare are the three most crucial things which a worker requires while working in a factory or in any industry. So, the Act looks into very intricate details with respect to these measures. Second object is that the employee should work in health and sanitary conditions so far as the manufacturing process will allow, which in turn would protect them from unnecessary diseases, unhygienic living conditions, which can only trigger occupational diseases or trigger other kinds of diseases and infections which they may be prone to. And the third object of the Act is precautions should be taken for their safety and for prevention of accidents. So, since a lot of factories have dangerous machinery, have very heavy machinery, have hazardous processes where the worker is more vulnerable to accidents, is more exposed to accidents and occupational diseases, sufficient precautions and preventive measures should be taken to protect them against these accidents, possible accidents, and occupational hazards. Next is the scope and applicability of the Act. The Act is applicable to whole of India. All the factories, including those belonging to the central government or the state government, are covered under the ambit of this legislation. unless otherwise excluded. Only factories which are specifically excluded under any regulation, under any notification, or under any provision are not covered for purposes of this legislation. And like every other labor legislation, for this act also the benefits are available to persons who are covered under the definition of worker under this act, which we shall be discussing eventually. The For the purposes of this act, there are four major definitions that have to be looked into: factory, manufacturing process, who is a worker, and who is an occupier. These definitions and more we shall be covering in the subsequent lectures.